Hello everyone, my name is Maggie LaBranche Gonzalez, and I'm an attorney with Litherland Kennedy & Associates. We're an estate planning and elder care law firm located in sunny Campbell, California. Now, you may have seen my vlog talking about the importance of funding your trust. Today I want to talk to you about what types of assets you should be funding in your trust. Now I want to remind everyone that in the state of California there is a limit that you can hold outside of the trust, and that limit is $166,250. Now, assets that have a joint owner or have a designated beneficiary, pay-on-death beneficiary or a transfer-on-death beneficiary, do not count towards this $166,000 limit. So in general, what types of assets should you be funding in your trust? Well, I think the obvious answer for most people is your real property. That's usually the largest asset in any estate. Any real property which you are the entire owner or own with another person, maybe an interest you own with your sibling or your parents, that interest should be titled in the name of your trust. How do you do that? You do that by recording a deed with the county where the property is located. Other types of assets that should be funded into your trust. All of your financial accounts. So your checking and savings accounts, CDs, brokerage accounts, safety deposit boxes, your bonds, any of those types of financial accounts should also be titled in the name of the trust. If you have a business interest, maybe you have an LLC or an interest in a corporation, your interest in that corporation can be held in the name of the trust. Also, life insurance. We typically recommend that your life insurance policy, the owner or the beneficiary, should also have the name of the trust. That way, there's a contingency already built in. The trust will continue on no matter what life throws at you. Now that I've said all of the assets that you should be putting into the name of the trust, there is one major exception. Yes, a huge exception that you're not going to put into the trust, and that is your retirement account. So think your 401ks, IRAs, pensions, 403bs. Those types of assets should not be titled in the name of the trust. Instead, what you're going to do is update your pay-on-death or transfer-on-death beneficiaries. In some cases, it may be the trust. If you're married, it may be your spouse and then the trust, or maybe it's just your beneficiaries. Now, I have a couple of tips. Number one, have your certificate of trust handy. It's a shorthand version of your trust. It says who you are and what your powers are as the trustee. In the state of California, you're not required to show the financial institution your entire trust document. It's an invasion of your privacy. They don't need to know all of that information. But the certificate of trust will help you fill out any form that they may give you. Number two, call your financial institution before you go down there and find out what do you need to provide them in order to transfer your account into the name of the trust. They may have their own certificate of trust form. They may have their own form that they have online that they need you to fill out. Maybe it needs to be notarized. Maybe they need both of you to go down there. It's always a good idea to find out first before you get down there and run in circles and everyone ends up frustrated. Number three, this is my most important tip. Please do not do the deeds for the real property yourself unless you truly have experience in doing deeds. The last thing you want to do is pass away and find out that the deed that you prepared was done improperly. Once again, you more than anyone else can determine the effectiveness of your trust. If you found this video, please like and subscribe. Thanks.